A Supreme Court decision expected in June 2026 could fundamentally change where you can carry your concealed firearm in every single state. The case is Wolford versus Lopez. Oral arguments were held on January 20th, 2026. And based on what happened in that courtroom, this could be the biggest Second Amendment ruling since Bruen in 2022. Here's what's at stake. Right now, Hawaii has a law that says you cannot bring your concealed firearm onto private property that's open to the public unless the property owner gives you express permission. That means restaurants, gas stations, shopping malls, beaches, banks, grocery stores, all off limits unless the owner says yes. Gun rights groups call this the vampire rule. Just like vampires in folklore can't enter a home without an invitation, gun owners in Hawaii can't enter private businesses without permission. And it's not just Hawaii. California, Maryland, New Jersey, and New York have similar laws. But here's the critical question the Supreme Court is deciding. Should the default rule be guns allowed unless the owner says no? Or should the default be guns prohibited unless the owner says yes? That might sound like a minor difference, but it's not. It's the difference between needing a no-gun sign at every Walmart or needing a guns welcome sign at every Walmart. And the Supreme Court's decision will set the rule for the entire country. If the court strikes down Hawaii's law, it creates a national default. Guns allowed on private property open to the public unless owners explicitly ban them. If the court upholds Hawaii's law, states can set their own default. And that means California, New York, and other restrictive states can keep their vampire rules in place. Quick question before we continue. Are you subscribed yet? Because what I'm about to break down is a pending Supreme Court case that could change concealed carry rights in all 50 states. And 90% of gun owners don't even know this case exists. Hit that subscribe button right now because when this decision drops in June, you need to know exactly what it means for you. Subscribe, turn on notifications, let's dive in. All right, let me start with the facts of the case because understanding how we got here is critical. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. That case struck down New York's May issue concealed carry law. Before Bruen, New York required you to show a special need for self-protection to get a concealed carry permit. The Supreme Court said that's unconstitutional. Justice Clarence Thomas wrote that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. New York had to change to a shall issue system. If you meet objective criteria like age, background check, and training, you get a permit. But here's what happened next. States like New York, California, and Hawaii didn't just accept the Bruen decision and move on. They passed new laws designed to comply with the letter of Bruen while restricting gun rights as much as possible. These laws are called Bruen response laws. Hawaii passed one in 2023. The law said, yes, we'll issue concealed carry permits to people who meet objective criteria. But even with a permit, you can't carry on private property open to the public unless you get express permission from the property owner. Express permission means the owner has to affirmatively say yes. That can be oral permission, written permission, or a sign at the entrance saying guns welcome. Without one of those, you're committing a crime if you carry inside. Now, 3 Maui residents, Jason Wolford, Allison Wolford, and Adam Kasperzicki, along with the Hawaii Firearms Coalition, sued the state. They argued Hawaii's law violates the Second Amendment. Their lawyer, Alan Beck, said the law is inconsistent with America's historical tradition of firearm regulation. The case went to federal district court. In August 2023, the district court agreed with the plaintiffs. The judge issued a preliminary injunction blocking Hawaii from enforcing the law, but Hawaii appealed to the Ninth Circuit Court of Appeals. And in September 2024, a 3-judge panel reversed the district court. The Ninth Circuit upheld Hawaii's law as constitutional. Here's what the Ninth Circuit said. Judge Susan Graber wrote the opinion. She found historical support for Hawaii's law. She pointed to a 1771 New Jersey law that prohibited people from carrying any gun on any lands not his own, unless he hath license or permission in writing from the owner. She also pointed to an 1865 Louisiana law that prohibited people from entering private property with guns without the consent of the owner or proprietor. The Ninth Circuit said these historical laws show that states have long been able to require permission before carrying guns on someone else's property. Therefore, Hawaii's law is consistent with the nation's historical tradition. The Ninth Circuit denied a request for en banc rehearing in January 2025. So the plaintiffs petitioned the Supreme Court for a writ of certiorari. And on October 3rd, 2025, the Supreme Court agreed to hear the case. Now here's why the Supreme Court took this case. There's a circuit split. The Ninth Circuit upheld Hawaii's law, but the Second Circuit struck down a nearly identical law in New York in a case called Antoniuk versus James in 2024. When 2 federal circuits reach opposite conclusions on the same legal question, the Supreme Court often steps in to resolve the conflict. That's exactly what happened here. If you're finding this helpful so far, Imagine what you'll learn in my next video, where I break down the 5 states most likely to pass vampire rules if the Supreme Court upholds Hawaii's law and what that means for your concealed carry rights. Subscribe right now so you don't miss it. All right, let's talk about what happened at oral arguments on January 20th, 2026, because this is where we got our first real look at how the justices are thinking about this case. Alan Beck argued for the plaintiffs. Neil Catchell argued for Hawaii. Beck's main argument was simple. Hawaii's law flips the historical default. Historically, the default was that people could carry firearms on private property open to the public unless the owner said no. Hawaii's law reverses that. Now, the default is no guns unless the owner says yes. Beck said that's unconstitutional. He pointed out that the 1865 Louisiana law that Hawaii relies on was part of the Black Codes. These were laws passed after the Civil War specifically to disarm black people. Beck argued it's absurd to use racist laws designed to oppress black Americans as justification for modern gun control. Justice Neil Gorsuch picked up on this point. He said it's ironic that people who normally react to black codes like garlic in front of a vampire are now citing them to support gun restrictions. Gorsuch asked Katyal directly why Hawaii would rely on a law aimed at freedmen. Katyal responded that Hawaii isn't endorsing the racist intent of the black codes. Hawaii is simply pointing out that states have historically been allowed to regulate guns on private property. The fact that some of those historical laws had racist motivations doesn't change the fact that they existed and were enforced. Katyal's main argument was this. An invitation to enter private property is not automatically an invitation to bring a gun. He said, and I quote, "It's pretty clear, an invitation to shop is not an invitation to bring your Glock." Katyal argued that property owners have a fundamental right to exclude. That right includes the right to exclude guns. Hawaii's law simply sets the default rule to respect property owners by assuming they don't want guns unless they say otherwise. Justice Sotomayor seemed sympathetic to this argument. She asked Beck whether people have a constitutional right to carry guns on private property. Beck said yes, the Second Amendment protects the right to carry in public, and private property open to the public is part of public space. Sotomayor pushed back. She said nothing about Hawaii's custom, tradition, or culture creates an expectation that the general public carries guns wherever they go. Justice Ketanji Brown Jackson also seemed to favor Hawaii's position. She said, you could have regulations that affect someone's interests, but don't actually implicate their constitutional rights. She suggested that Hawaii's law is about property rights, not gun rights. But the conservative justices seemed skeptical of Hawaii's arguments. Justice Amy Coney Barrett asked about the distinction between the First Amendment and the Second Amendment. She pointed out that under First Amendment law, you generally have the right to speak on private property open to the public unless the owner asks you to leave. She asked why the Second Amendment should be treated differently. Katyal responded that the First Amendment rules are different from the Second Amendment because possession of a gun is different from speech. But Barrett didn't seem convinced. Justice Clarence Thomas questioned why Hawaii relied on laws from the Reconstruction era. He suggested that post-14th Amendment laws should carry more weight than earlier laws because the 14th Amendment fundamentally changed the constitutional landscape. Overall, the oral arguments suggested that the court is divided. The 3 liberal justices, Sotomayor, Kagan, and Jackson, seemed inclined to uphold Hawaii's law. The conservative justices seemed skeptical. The key swing votes could be Chief Justice Roberts and Justice Barrett. If both of them vote to strike down the law, it's a 6-3 decision against Hawaii. If one or both vote to uphold, it could be a narrower decision or even a win for Hawaii. Now let's talk about what's actually at stake here. If the Supreme Court strikes down Hawaii's law, here's what happens. The default rule nationwide becomes guns allowed on private property open to the public unless the owner posts a no-gun sign or verbally tells you to leave. That means in all 50 states, you can carry your concealed firearm into any restaurant, gas station, grocery store, shopping mall, or bank unless the owner has explicitly banned guns. States cannot impose a blanket presumptive ban. They cannot require you to get permission before entering. This would be a massive expansion of gun rights. It would invalidate similar laws in California, Maryland, New Jersey, and New York. It would also prevent any other state from passing a vampire rule in the future. For gun owners, this is a huge win. You don't have to guess whether a business allows guns. You assume yes unless you see a sign or are told otherwise. But here's the flip side. If the Supreme Court upholds Hawaii's law, states retain the power to set their own default rules. Hawaii can keep its vampire rule. California, Maryland, New Jersey, and New York can keep theirs. And other states could pass similar laws. For example, imagine Illinois decides to adopt a vampire rule. Now, even if you have a concealed carry permit in Illinois, you can't carry in any private business unless the owner gives you permission. How do you get permission? You have to ask, every time, or the owner has to post a guns welcome sign. In practice, most businesses won't post signs either way, so you're left in a legal gray area. Are guns allowed or not? You don't know. And if you guess wrong, you're committing a crime. This creates a chilling effect on the exercise of Second Amendment rights. Gun owners will choose to leave their guns at home rather than risk accidentally breaking the law. Hey, quick reminder. 73% of people watching this video right now are not subscribed. That means you're going to miss the Supreme Court's decision in June, and you won't know how it affects you. Don't be in that group. Over 50,000 gun owners rely on this channel for accurate, up-to-date legal information. Click subscribe right now. All right, let's talk about the legal test the court will use. In Bruen, Justice Thomas established a new framework for evaluating gun laws. The test has 2 steps. Step 1. Does the Second Amendment's plain text cover the conduct the challenger wishes to engage in? If yes, move to Step 2. Step 2, is the challenged law consistent with the nation's historical tradition of firearm regulation? If no, the law is unconstitutional. In Wolford, Step 1 is pretty clearly yes. The Second Amendment protects the right to bear arms. Carrying a concealed firearm on private property open to the public is bearing arms. So the question is, Step 2, is Hawaii's law consistent with historical tradition? Hawaii says yes. They point to the 1771 New Jersey law and the 1865 Louisiana law. Both required permission from the property owner before carrying guns on private land. The plaintiffs say no. They argue those laws are not good analogs. The 1865 Louisiana law was a racist black code. The 1771 New Jersey law was about trespassing, not about public accommodations. The plaintiffs say the relevant historical tradition is that people could carry guns in public spaces, including private businesses open to the public without needing permission. This is the core dispute, and it's the same dispute that's playing out in dozens of Second Amendment cases across the country post-Bruen. What counts as a historical analog? How similar does a historical law have to be to justify a modern restriction? The Supreme Court will have to answer those questions in this case. Now, let me give you some real-world scenarios to show how this plays out. Scenario 1. You live in Hawaii. You have a concealed carry permit. You're carrying your gun. You stop at a gas station to fill up. Under Hawaii's current law, you cannot bring your gun inside the gas station unless the owner has posted a guns welcome sign, or you ask and get permission. If you walk in without permission, you're breaking the law. If the Supreme Court strikes down the law, you can walk in by default. The owner has to post a no-gun sign or tell you to leave. Scenario 2. You live in Florida. Florida does not have a vampire rule. You can carry in most private businesses unless they post a no-gun sign. If the Supreme Court upholds Hawaii's law, Florida could pass a vampire rule. Now you'd need permission to carry in businesses. This would be a huge change. Scenario 3. You're traveling from Texas to California. You have a Texas concealed carry permit. California recognizes some out-of-state permits under certain conditions, but California has a vampire rule. So even if your permit is valid, you can't carry in private businesses without permission. If the Supreme Court strikes down California's law, you can carry in those businesses by default. Scenario 4. You're at a shopping mall. The mall is private property, but it's open to the public. Under Hawaii's law, you need the mall owner's permission to carry. But what if one store in the mall posts a guns welcome sign? Does that count as permission from the mall owner? Or do you need permission from both the mall owner and the individual store owner? This is the kind of legal ambiguity that creates problems for law-abiding gun owners. Quick legal note. This is educational information only. It is not legal advice. Supreme Court cases are complex and state laws vary. Always consult a licensed attorney for your specific situation. Do not rely on this video to make legal decisions about carrying firearms. Now let's talk about what you should do while waiting for the decision. First, if you live in Hawaii, California, Maryland, New Jersey, or New York, you need to follow the current law until the Supreme Court rules. That means you cannot carry on private property open to the public without express permission. Even if you think the law is unconstitutional, violating it now will result in criminal charges. Wait for the court's decision. Second, if you live in a state without a vampire rule, pay attention to your state legislature. If the Supreme Court upholds Hawaii's law, your state could pass a similar law. Stay informed about proposed legislation. Contact your state representatives. Let them know you oppose vampire rules. Third, join organizations that are fighting these cases in court. The plaintiffs in Wolford are represented by lawyers from gun rights organizations. Your membership dues and donations fund this litigation. The NRA, Gun Owners of America, Firearms Policy Coalition, and Second Amendment Foundation are all active in these fights. Fourth, understand that this decision will likely be narrow. The Supreme Court could rule broadly and set a clear national standard, or the court could rule narrowly and leave many questions unanswered. For example, the court could strike down Hawaii's law, but only because it relies on black codes. That would leave open the possibility that a different state could pass a vampire rule based on different historical evidence. Or the court could uphold Hawaii's law, but only for certain types of private property like bars or schools. That would leave open challenges to the law as applied to gas stations or grocery stores. The point is, don't expect one decision to settle every question about where you can carry. This is an ongoing legal battle that will continue for years. Fifth, document everything. If you're ever told to leave a private business because you're carrying, ask for a written statement of the policy. Take photos of any signage. Keep records of when and where this happens. This documentation could be critical if you ever need to challenge an enforcement action, or if your state passes a vampire rule and you want to challenge it in court. And sixth, be respectful of property owners. Even if the Supreme Court strikes down vampire rules and establishes a guns allowed default, property owners still have the right to ask you to leave. If a business owner tells you guns aren't allowed, you have to comply. You can choose not to do business there, but you can't stay on the property against the owner's wishes. That's trespassing, and the Second Amendment doesn't protect trespassing. All right, let's bring this home. On January 20th, 2026, the Supreme Court heard oral arguments in Wolford versus Lopez. The case is about whether states can require gun owners to get permission before carrying on private property open to the public. Hawaii says yes. The plaintiffs say no. Based on the oral arguments, the conservative majority seemed skeptical of Hawaii's law, but the decision is not guaranteed. We won't know the outcome until the court issues its opinion, likely in late June 2026. If the court strikes down the law, it will create a national default. Guns allowed on private property open to the public unless the owner says otherwise. If the court upholds the law, states can continue to impose vampire rules, and other states could pass similar laws. This is one of the most important Second Amendment cases since Bruen. It will affect where you can carry your concealed firearm in every state, and it will shape the future of gun rights litigation for years to come. This information could literally determine where you can legally carry, starting in June 2026. Subscribe now, because I will break down the Supreme Court's decision the moment it's released. Hit that subscribe button. Share this video with any gun owner who needs to understand what's at stake, and I'll see you in the next one where we break down the other major Second Amendment case pending at the Supreme Court. Legal disclaimer. This video is for educational and informational purposes only. It does not constitute legal advice. Supreme Court decisions are pending and state laws vary. Always verify current law and consult a licensed attorney for your specific situation. This video reflects information as of early 2026 and may not include the most recent developments.